you've tried counseling over and over and over again, or your spouse simply won't even bother showing up, and you've reached the end of the road of your marriage and you want out. Hello, my name is attorney Danielle Pinkston. I am owner and founder of Pinkston Law Group, and welcome to What You Should Know Wednesday. Our topic today is dissolution of marriage pursuant to 750 ILCS 5/401. Divorces are a very unfortunate part of our society. No one goes into a marriage thinking, I cannot wait to get out. But, unfortunately, people marry the wrong person for the wrong reasons at the wrong time, or circumstances arise during the marriage that dissolve the bonds of marriage. Today, I will discuss the basics of what you need to know in order to get a divorce in Illinois. And the first thing I'll talk about are the parties. We have the petitioner and the plaintiff, and this is the spouse that initiates the divorce proceeding in a domestic relation court in Illinois. We then have the respondent or defendant, and this is the party that does not initiate the divorce proceeding, but they simply receive documents from the petitioner and they answer. You do not get your way just because you are a petitioner and you filed your divorce first. Similarly, you do not lose all that you have because you were not the first person to file a divorce and you are the respondent. So you're wondering, how do you begin an action for a divorce? As any other action in a civil court or proceeding, you have to file your case with the clerk of the circuit court where at least one of the parties resides. The filing fee is $368. The appearance fee for the respondent is $237. And there are several ways that you can serve the party the petition and the summons. The first way is through the sheriff department. Again, you simply take your petition and whatever documents that you have that go along with that and take it to the sheriff's office, and they will make the first attempt at service. If you live in a county that is under a certain amount of people, population is a little small compared to Cook County, you may be able to use a special process server initially. Or the person can voluntarily appear or consent to appear in your divorce proceeding. If the sheriff is unable to serve the respondent your complaint and petition, then you can go to court with a motion asking the judge to allow you or to have the court appoint a special process server. And this person will make several attempts at serving the respondent your complaint or petition and the actual summons. If you've tried service several times with the sheriff and a special process server with no avail, then you can also file a motion with the court asking that you be allowed to serve the respondent via publication or service via another method that the court has allowed you to, which is known as a special order of the court. Timeframe. So you're wondering, you filed your petition for divorce, you have a summons, you've served the person, the petition and the summons. You're wondering, how long will it take before you're able to obtain your judgment in your divorce proceeding? Well, that varies from case to case. There is no bright line, or there is no standard that says divorces take X amount of days or months or years. Okay? You can expect to wait as little as 2 or 3 weeks to get a divorce, or sometimes 2 years, depending on how the parties cooperate with each other. Now, there are certain documents that you need. Some documents are mandatory, other documents are optional, and I'll go over the mandatory documents first. Again, before you can get a judgment, you must file a petition for dissolution of marriage. You must also have an affidavit of service. And again, I mentioned several different ways that a person can be served, but you have to have an affidavit indicating the person was served on this date at this location. Third document that is mandatory, you have to have an appearance from the respondent. Okay, again, they have to file their appearance and pay an appearance fee before you can get a divorce. In addition, you have to have a proposed judgment on your date of dissolution of marriage. Again, this judgment has to be typed out or written out. It's advised to type it out. But again, you have to let the court know that you've taken time, you've gone over your divorce petition, and you've drafted a judgment, and you're asking for certain things from the court to, one, dissolve your bonds of marriage, and you may also ask to revert back to your maiden name, to name a few. Optional documents. Certificate to hear as uncontested matter. What this means is both parties have read the petition for dissolution of marriage. They are in agreement, and they would like to have their divorce done sooner than later, and they both sign this. A notice of motion. This can be waived, but again, it's an optional document that you may want to bring with you. a marital settlement agreement. A lot of times in divorces, parties will get together and try to resolve their marital issues of assets, property, debts, things of that sort. And they have this in a written document that is incorporated into their divorce judgment. If you have children, you will need to have a parenting plan. So this should have actually been a mandatory document. Because again, if you have children, within 120 days after filing your petition, you need to have a parenting plan also filed with the court. If there are things like pensions, 401ks, etc., and so forth, deferred compensation, then you should also have a qualified domestic relation order or a quildro or quadro. It's better to get this done during the actual divorce proceeding, because if you wait, you'll have to come back to court, you'll have to file a motion, you'll have to have a hearing and do it that way. It's just less time and less money if you get it done during the actual divorce. And also, you have to have an order for filing transcript. If a court reporter was present in court during your divorce, you may have to have the actual transcript filed with the court. Sometimes judges will waive this, but again, you should make sure that you know if there was someone present or if the judge is going to waive it, because if not, you have to actually file the transcript with the court. And I did fail to mention one document you need. If there are children involved, you must also have a uniform order of support. Again, this is required if there are children involved in your divorce proceeding. So you may want to know, you may wonder, what are the grounds that you need to allege in order to get your divorce signed, sealed, and delivered? Well, prior to January 1st, 2016, there were several different grounds that one could allege in their petition, but now we don't have to do that. All you have to do now is state that irreconcilable differences have caused the irretrievable breakdown of the marriage, and the court determines that efforts at reconciliation have failed, or that future attempts at reconciliation would be impractical and not in the best interest of the family. That's all you need to have in there. Again, you don't have to allege abuse. You don't have to allege adultery or, any of those other for-cause reasons. Just allege there has been irretrievable breakdown of the marriage. And again, parties have tried to work things out and they were unsuccessful. Also, in order to get a divorce, the parties must have lived separate and apart for a continuous period of not less than 6 months immediately preceding the entry of the judgment dissolving the marriage. And again, there is an irrebuttable presumption that the requirement of irreconcilable differences has been met. When I say separate and apart, I don't mean that the husband and wife have to live outside the home. You can live under one roof, the marital roof or marital home, and still be living separate and apart. You just cannot be living as you lived when the marriage was intact and things were going well. Essentially, you should not be having sexual relations or intercourse with your spouse if you are being considered to live separate and apart. Counseling. You may be wondering, will the court make us go to counseling? And again, the court will order you to mediation sometimes if they believe that, again, a mediator or third party or neutral person can hear both sides and try to get the parties to come to some sort of resolution. And again, if you're in court and the judge feels that, again, as husband and wife, you all still have a tremendous bond, and maybe going to counseling once or twice might make things better for the parties, they can require you to go. What I advise all of my clients to do is actually to go to counseling. Try it once, try it twice, because you never know. Perhaps there was just this one little issue that, if worked out, would make everything in the marriage better. So I would advise you all, if you're thinking about getting a divorce, try counseling. Try it once, try it twice, try it a third time. And then after that, after you've tried to make it work and things still are not working out, then go ahead and file your petition for dissolution of marriage and get a divorce. Okay? In addition to what I've already mentioned to you before, there are certain local rules in every county of Illinois. In Cook County, we have what's called a Local Rule 13.3.1. And what this means is each party shall serve a completed affidavit of incomes, expenses, and debts and assets upon the other party. And the form is called a 13.3.1 financial affidavit or financial disclosure. In addition, in Cook County, we have a Local Rule 13.3.2. And if you have to serve a 13.3.1, you should also accompany this document with 2 years or 2 calendar years of federal and state income tax returns, pay stubs, or something indicating that your year-to-date income is as follows. Okay? Discovery. Before you get a divorce, it is very advisable that you conduct discovery. What I mean is Supreme Court Rule 213 and 214 allow litigants to issue 30 or more questions, depending on what area of the law it pertains to, asking the other person, the other spouse, about their income, about their assets, about their debts, about their parenting plan, so that you are an informed person. Again, you don't really want to get a divorce unless you know what the other party has as far as assets, because you could be waiving and barring spousal support or maintenance when you very well may have been entitled to something, or even marital property. Some property your spouse may have that you don't know about, but you may be entitled to that. So make sure that you conduct discovery and you tender Supreme Court Rule 213. Now, Supreme Court Rule 214 states that a person, a litigant, can serve upon the other party a document that asks them to produce certain documents. So again, you want to be a fully informed petitioner or respondent before you get a divorce to make sure you're not waiving and barring something that you may have a legal right to. Well, that's all the time I have for today. I hope that today's What You Should Know Wednesday segment was very informative and answered questions that you've had. Keep in mind, What You Should Know Wednesday is never intended to take the place of a one-on-one consultation. So if you believe you have more unanswered questions or you need more legal help, please call my office at 773-770-4771. Again, 773-770-4771. Also, you can now schedule your consultation online at pinklaw.acuityscheduling.com. Again, that is pinklaw.acuityscheduling.com. Thank you for tuning in, and I will see you next week for What You Should Know Wednesday.